I really worry about the blah, 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 et cetera, given that the district court didn't make findings on several of the things we told it needed to.
The 4-day trial, 16 to 18 expert witnesses, 250 exhibits. I think this is the first time we've had a full trial record. Any federal appellate court in the country has had a full trial record. Isn't that an uphill battle for the state to overcome those findings?
The United States' position is that AR-15s and similar weapons are clearly arms that are protected by the Second Amendment. They are not militaristic. Militaristic analysis is not even a correct rule to apply. It is not found in Supreme Court precedent. It is not appropriate historically, and it is not appropriate in the context of today. And so for these reasons, we believe that it's the incorrect test to apply.
That is just some of the highlights from yesterday's oral arguments in the Seventh Circuit U.S. Court of Appeals challenging Illinois' gun and magazine ban. Welcome in. It's Illinois in Focus Daily. I'm Greg Bishop, editor of the Center Square, Illinois. Go to the Illinois page and find the latest headlines, including just one story of yesterday's oral arguments. There's going to be plenty that comes after, including continued analysis. So let's, this segment, focus on what was heard in the court yesterday. And how we got to this point, right? So we're at the merits of the issue in the appeals court. The next step could be the U.S. Supreme Court to deal with the question of whether a government can ban or whether a state can ban semi-automatic firearms that plaintiffs say are commonly owned firearms for lawful purposes. So back in 2023, Governor J.B. Pritzker enacted the Protect Illinois Communities Act. It prohibited the sale of and possession of more than 170 semi-automatic firearms, pistols, shotguns, rifles, all kinds of attachments being banned, magazines over certain capacities for shotguns, rifles, handguns being banned, criminal penalties being associated with possession of those if they're not registered with the state, and there was a deadline to register those with the state after the law became effective. So it's been in effect since January 2023, only 6 days where it was not in effect, and that was on preliminary grounds in the district federal court where Judge Stephen McGlynn, on the initial request to temporarily block the law from being not enacted but enforced, there was that 6-day window on preliminary grounds. That was back in 2023, I think like April or so. And then that went all the way up to the appeals court. The appeals court reversed that 6-day window, and then it even went up to the U.S. Supreme Court on preliminary grounds. And those preliminary grounds, the U.S. Supreme Court said, no, we're not going to take the case. It's not ripe yet. So went back to the district court in 2024, where they debated the case on the merits with a 4-day bench trial, with thousands of pages of records, testimony from all kinds of different experts on both sides of the equation here. And then the federal district judge last year ruled the law was unconstitutional. Now, he put a stay on his own order. A stay is essentially saying it's not going to prohibit the law from being enforced yet until the appeals court deals with it. Then the appeals court got the case from the state because the state was found to be enforcing an unconstitutional law by the district court. And then it gets to the appeals court. The appeals court keeps the district court stay on. So the law is still in effect, even though the district court said it's unconstitutional. So now we had the appeals court hearing yesterday. So let's get right into it. You have the states defending the law, saying that M16s and AR15s are very similar, but you've got a 3-judge panel here. And we're going to hear voices from Judge Michael Brennan, Judge Frank Easterbrook, and Judge St. Eves. And as we talked with Dan Eldridge yesterday, all eyes on Amy, he said, because St. Eve is a new judge on this 3-judge panel. Diane Wood used to be the 3rd judge on this 3-judge panel, but she retired, so they replaced her with Amy St. Eve. So that's the 3rd voice you're going to hear. Let's get to the highlights.
It remains undisputed that when fired in semi-automatic mode, the M16 and the AR-15 have identical capabilities and lethality. It's also undisputed that the military typically uses M16s in that semi-automatic mode.
What about, Ms. Hunger, the argument that one of the state's expert witnesses talked about the fact that they would never send semi-automatic firearms into battle, that automatic capability is important?
The state does not dispute that the automatic capabilities can be used in certain circumstances, such as suppression fire, and also that that can have a utility. It's also important to note, however, that all of the experts, including the plaintiffs' experts, agreed that that was rarely used, that automatic capability. And part of the reason is because when troops are sent into battle, they typically also have an individual that has an M249, which provides suppression fire. And so typically, individuals that have the M16 are using semi-automatic fire, and it's only in kind of unexpected or rare circumstances that they would use that for automatic fire, but that is a capability that is used. Yeah.
So the argument, went back and forth with some questions from Judge Brennan. You had other judges asking questions from the 3-judge panel, but Brennan said that it seems to be an uphill battle for the state to defend the law, given the large record that was created in the district court.
Isn't it an uphill battle, though, for the state? Here we've got a clearly erroneous standard of review. We've got a district court who held a 4-day trial, 16 to 18 expert witnesses, 250 exhibits. I think this is the first time we've had a full trial record. Any federal appellate court in the country has had a full trial record. Isn't that an uphill battle for the state to overcome those findings, like M16 is different than AR-15?
No, Your Honor, for 2 reasons. The first is because de novo review applies here, and I'm happy to get into that. But also, I'm happy to address any statement under a clearly erroneous standard that the district court made and show why we believe that we can overcome it, either because it's actually undisputed, or because it's disputed but not dispositive, or because it was clearly erroneous. But that being said, de novo review...
But your de novo review wouldn't apply to the district court's findings of fact, which I know you have argued the district court didn't make them, and I think maybe you should move on to the fact that there were some made, not in your traditional, here's your findings of fact and conclusions of law, but the law doesn't require a particular format. So the district court did make specific findings differentiating AR-15s from M16s and M4s, and how do you get around that?
And these are really interesting questions that the judges are asking of the state, including Judge Amy St. Eve asking those targeted questions towards the state, and the state having to, formulate responses to those. But the states talked about self-defense, and in particular, the issue of, what exactly is self-defense.
So we have empirical evidence in the record showing that these weapons are not necessary for self-defense. They're not chosen by individuals for self-defense. They're not even the most useful for individuals in self-defense. And on the other side...
Is the Lucy Allen report focused on Illinois, or is it broader?
It's broader.
And would your statement that you said earlier about not using AR-15s for outside of the home because of gun regulations here, would that impact the Lucy Allen report at all? So could her statistics be off if her focus was not based on Illinois and the concealed carry, etc.?
No, I don't think so. I mean, in this kind of universe, to be perfectly honest, is we have just different types of data available for these things, and Lucy Allen looked for the type of data that she could get, and that's what she could find. In other states, there are state-specific databases. I'm not aware of any in Illinois, and so I think her scope was national.
And again, this is evidence that the state was providing, talking about the types of firearms that are used in self-defense more often than not, and it's typically handguns. And it seemed to be a way to try to balance of sorts the state's trying to say what kinds of firearms people can use to protect themselves. But then Brennan asked about what kinds of historical analogs there are to say that there were firearms prohibitions during the founding era. Again, a precedent that was set by the U.S. Supreme Court.
Everyone tells us that we're to look to the how and the why of the law to determine its analogousness.
Yes.
That one weapon ban that you're talking about, how does that satisfy the how? Or how does that satisfy the why?
So it was a ban on possession of trap guns in 1771 in New Jersey. That was the example that I was thinking of. And then let's see here, there were 8 more of those bans in the 1800s and 9 in the early 1900s, and then there were bans on Bowie knives all throughout the 19th century, then semi-automatic and automatic weapons.
And we're to look to the how and the why of the
Yes.
ban. That's where there's trouble for the state on that second step, isn't there?
No, there isn't, as this court held in Bevis. I mean, I think to reach that conclusion would require reaching a different result than the one that this court reached in Bevis. And because the historical tradition is about reserving, dangerous weapons for law enforcement and military use and restricting civilian access to these especially dangerous weapons in a manner that is appropriate for the danger that they pose. And so these, weapons, trap guns, of course that's why you would ban the possession, because you don't want a trap gun at your house.
So the trap gun issue, something that we're going to flash forward from the states, because how they set this up is the state gets 45 minutes and the plaintiffs get 45 minutes. So we're still in the state defending the case that was found unconstitutional by the district judge. But I'm just going to flash forward because, she brought up this trap gun ban back in the 1770s, and Thomas Magg, who was representing the Langley plaintiffs challenging the gun ban, he got a 5-minute chance to talk about some things, and he specifically talked about that particular issue.
But what was discussed earlier in the debate, some of the questions back and forth, was questions whether there were historical bans on types of firearms, and a trap gun was brought up. And I think trap, to a lot of people in the shooting sports today, probably refers to shooting clay birds. Well, that's not what they banned. A trap gun is a booby trap. It's something designed to be set in an unoccupied structure to kill burglars and trespassers. Well, I mean, human lives are far more valuable than property, and so many states probably justifiably banned the setting of trap guns, spring guns, booby traps, as they should have. And then, of course, I mean, there is no legitimate function, no self-defense function, no military function, no sporting function for a booby trap. So, I mean, that's what that had to do with.
So again, Mag had his opportunity in front of the appeals court. Just wanted to kind of flash forward to that. But back to the states arguing for the gun ban. Judge Eve was talking with the state attorney representing the state and said, listen, the Bevis situation is at play here, and it may not mesh with the U.S. Supreme Court precedent.
I think the first Bevis was shortly on the heels of Bruin, and we were one of the first courts to tackle the challenges of Bruin. There has been additional case law that has come out, including Rahimi.
Yes.
What is the state's position as you're here today on how we should construe dangerous and unusual? Is it dangerous and unusual, dangerous or unusual, unusually dangerous? The courts that have addressed it are a little bit all over the place.
A little bit, but I was actually reviewing the decisions for that issue a couple of days ago, and in addition to Bevis, the Lamont, the Bianchi, and the Hansen decisions have kind of centered around this particularly dangerous, especially dangerous terminology that was used by this court. So that would be, I think, 4 out of the 5 or 6 circuits that have addressed this. So even though they use different terminology, perhaps some's especially dangerous, some's particularly dangerous, it actually was a lot more coalesced than I perhaps expected to find when I set out to read them.
Now, the plaintiffs do argue that, the dangerous element is, focused on firearms or weapons that are indiscriminate. Things like grenades or, chemical weapons and the such. So, just kind of countering here what you're hearing from the state defending the law and the questions that the judges are asking. Brennan asked the state about the unprecedented societal concerns over mass shootings.
I think that although there were certainly mass murders, and this is also in the record, there were mass murders, but there were not mass shootings. And if you look at the act that is at issue here, it is designed to address mass shootings, and that is a new societal concern. It is not attempting to address homicides or mass murders more generally. And it does not say that it is attempting to do that, because it's not regulating other types of actions that could lead to mass murders. It is regulating the weapons that are used in mass shootings, and that is a change, and also the technology has changed.
I'm losing you where the change happens, because there have been mass shootings as that's defined going.
And we don't dispute that there were some mass shootings 30 years ago, but there are a lot more mass shootings that are happening now. And, as Justice Barrett indicated in her concurrence, legislatures do not lose the ability to regulate simply because they did not do it at the earliest possible moment.
So again, you've got the ongoing debate between the judges and the states as to how they can justify the state's ability to ban what the plaintiffs call commonly owned firearms. All right, so that's just an encapsulation of the state's arguments. Now we have some time here left before we jump over to the next segment with Todd Vandermeide, but I wanted to share with you what the plaintiffs were saying. Aaron Murphy is talking about the differences between AR15s and M16s, and says that the record in the district court really spells that out.
And what it explained is, from the court's perspective, after understanding all the record evidence, that really what puts something on the military side of the line is automatic fire. And that automatic fire is different because it serves a suppression need, and that's why, and that the military has. The military may need to pin troops in place, keep people from advancing as you're trying to enter a structure to clear it, where you don't pin troops in place, keep people from advancing as you're trying to enter to clear it, where you don't know who your target is, and you don't care if you're firing as accurately, you just want to fire quickly. That's like the opposite of what Illinois is coming at here, because as the court explained it, I don't think Illinois disagrees about this. It's singling out features here because they make firearms more accurate. They make it easier for someone to stay on target. So it's singling out the very thing that drives an even bigger wedge between an automatic firearm that is military grade and a semi-automatic only firearm that I don't think there's any dispute is not something that has ever been a service issue combat rifle in our military or any other military in the world. And what the district court said is, once the court looked at things like rate of fire and control, that's the big differentiator, and that in the self-defense context, you just don't have that same need for suppression fire that you might in the military context, because as this whole case is about showing, people want firearms in the self-defense context that are more accurate.
So Aaron Murphy, representing the plaintiffs in this case, laying out her case. Judge Frank Easterbrook, he jumped in and interrupted.
I really worry about the blah, 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 et cetera, given that the district court didn't make findings on several of the things we told it needed to.
And he went on to complain about the district court not looking at the rate of fire as an issue that needs to be addressed, or the capacity of magazine issue that needs to be addressed. But back to the crux of the argument, more from Aaron Murphy.
So I think that, as I understand what the Supreme Court is saying about our historical tradition, it is one as between the people and the government choosing which weapons are best suited for the people's self-defense, we defer to the views of the people. Now, in some instances, that's easy to do because you can look at some things, and we would submit this case as one where it is easy to do because even by the state's experts' estimation, 14 to 18 million individuals own AR-15 style rifles, and many, many more own the magazines that are banned here. And there's simply no real dispute that they own them for the purpose of self-defense. They'll dispute whether they think they need them. But if you're just asking that, we think this is an easy case. I think, the answer most consistent with the Second Amendment is you don't jump in and try to ban things until you actually really think there's a problem with them. And if something's coming on the market that seems like it just makes firearms do what they're supposed to do better, i.e. be more accurate, easier to use, maybe a little faster, but faster in a way that doesn't sacrifice accuracy, it's pretty odd for the state to say, we want to jump in and say, no, you have to stick with outmoded technology. If you have something that comes on the market that's meaningfully different, say in a way that, I think when you look at the things historically that people have been happy to see banned, one commonality you see among them is an indiscriminate nature. Grenades, chemical weapons, the idea of handheld nuclear weapons.
So again, that's Aaron Murphy representing the plaintiffs. Judge St. Eve asked questions of Murphy.
How do we think about that a lot of the mass shootings, especially those that have included a large number of victims, these weapons were used for illegal purposes. You said 14 to 18 million legally own them for legal purposes, self-defense, but there are also these statistics on the other side. Does that factor in with the nuanced approach or the societal concerns? What are we supposed to do with that?
I mean, the answer is I don't think what you can do with that is say that's a reason that they're wholly unprotected by the Second Amendment, because that's an argument that says, okay, we're going to focus instead
But that would be on the arms question.
Well, I
not
think on
the-
either question, because, I just don't think there's a tradition in this country of saying that particular weapons, because if somebody, who was going to misuse them got their hands on them, they would be very dangerous. I mean, every weapon is incredibly dangerous in the hands of someone who wants to misuse. And I would note that the state's own expert on this said that it's about 20% of mass shootings that a Illinois-defined assault weapon is used in, and less than half that an Illinois-defined large-capacity magazine is used in. So,
But I thought the expert also said once you start getting into higher numbers of deaths, that those numbers go up.
And I think that's part of why this, I don't think, with all due respect to my friend on the other side, that there's a kind of generally accepted easy way to conceptualize what is and isn't a mass shooting.
The nuance, the legalities, the questions. This is how these things go when they are debating these and in oral arguments. Doesn't matter what the attorney has in front of them as their script to make their arguments. Judges are going to interrupt. They're going to jump in with their questions. They have a limited amount of time, so they're going to ask those questions. So the plaintiffs split up their 45 minutes. Aaron Murphy had time, the most of it. Thomas Magg had time. We heard a little bit from him. But the U.S. Department of Justice was there. Harmeet Dillon, the Assistant Attorney General for the United States Department of Justice in the Civil Rights Division, there to argue on behalf of the plaintiffs suing the state over the gun ban. And Dillon started off their argument.
Assistant Attorney General Harmeet Dillon for the United States as amicus in support of plaintiffs' appellees and supporting affirmance of the district court's opinion. The United States has a strong interest in ensuring that the Second Amendment is not relegated to a second-class right, and that all the law-abiding citizens of this circuit remain able to enjoy the full exercise of their Second Amendment rights as binding Supreme Court precedent requires. The law at issue, a so-called assault weapons ban...
Let me ask you about the standard of review again.
And that is Judge Easterbrook jumping in with a question to Dillon.
Suppose the district court had found every contested issue of fact in favor of the state. Would that affect your view of the statute's constitutionality?
It would not, Your Honor. And
So you don't think the facts matter?
the facts would
Right.
matter, but...
What matters to me is that we know we have 4 essentially identical cases pending before district judges in this circuit. And one thing that worries me is what happens if they don't agree with each other. But you suggest that that's not going to matter.
If I may, Your Honor, I did not get the chance to complete my argument, which is that we believe the standard at this court's level was inaccurate. We do not support the militaristic formulation. And so the district court went to some great lengths to harmonize Heller and Bruin with this court's opinion. But it's the position of the United States that the Bevis standard is at odds with the Supreme Court standard. And so had there been some different factual findings under the rule set by this court, it wouldn't affect my opinion as to the constitutionality of the statute.
Just a couple of more clips here before we get to Todd Vandermeid in the next segment. The Department of Justice making their case with Harmeet Dillon there. Judge St. Eve asking questions of Dillon.
And is it your position that it's because Bevis requires these factual findings, whereas the test that you would propose does not?
No, Your Honor. The factual findings would have to be made in any case. And so I don't mean to imply that one could reach a conclusion on the constitutionality without engaging the analysis as to whether this particular law meets the two-part analysis of both having met the historical tradition of dangerous and unusual. We accept that standard. But the question of what is an arm in the first part of the test is affected by this court's ruling in Bevis. And I think that is where we would disagree at the United States level, because I think the trend in the Supreme Court is very clear, as Judge Easterbrook indicated. It is, the clues are there that the Supreme Court in the justices who have addressed this issue, particularly Justice Thomas in his dissent from Cert and Snope, has indicated that with 41 states accepting AR-15s as arms that are legal for Americans to possess for legitimate purposes, they are presumptively legal. And then the legislature has to come up with the justification under the historical dangerous and unusual test. And I think the district court in this case did a good job harmonizing Beavis with Heller and Bruin and reaching its own determination of historical and dangerous. We accept those determinations for purposes of this appeal.
And again, this is Harmy Dillon, the Assistant U.S. Attorney General, there at the Seventh Circuit U.S. Court of Appeals, closing out her arguments before the judges took the case under advisement.
The United States' position is that AR-15s and similar weapons are clearly arms that are protected by the Second Amendment. They are not militaristic. Militaristic analysis is not even a correct rule to apply. It is not found in Supreme Court precedent. It is not appropriate historically, and it is not appropriate in the context of today. And so for these reasons, we believe that it's the incorrect test to apply.
So there you got the case in the hands of three justices of the appeals courts. What exactly do we take away from this? It's a great question. We'll get some analysis here with Illinois in Focus Daily. I'm Greg Bishop, waking you up each and every weekday morning. Hit subscribe, like this video, share it up. We do this each and every weekday morning here for the Center Square. So go to thecentersquare.com and sign up for the headlines in your inbox each and every weekday morning. Again, thecentersquare.com.